few episodes ago, we spoke about the GAAR, and now there's another case dealing with some of the substantive provisions of the GAAR. So that's what we'll be talking about today in this episode of Tax Break, your podcast for South African tax professionals and practitioners. As always, I would like to ask you, if you like the podcast, please rate it, like it, and subscribe for it on your favorite podcast platform. And or tell all your friends and colleagues about it if you think that they would also like to listen to the podcast. I just want to remind you about the app that I've developed. If you've got any ideas for the podcast, the companion app. So if you look at tax.pvdz.co.za/app, so app, I've developed an app where you can post your ideas for new episodes, and other listeners can go to the app, and if they like the idea, they can rate it there, and that would then help me to understand what you would like to hear more about on the podcast. I've also developed something else. So I've been busy playing with all the AI tools, and I've realized that there's actually a lot one can do with them. I've developed a function that I've embedded on my website. So if you go to the website tax.pvdz.co.za, and you just scroll down a little bit, there's a box where you can ask any tax question. So you can type in any question that you've got, any fact pattern that you are looking at. And using AI, that box will then go through all the content that I've developed over the years, all the articles, the podcast episodes, all of those things, and suggest to you what you can look at if you want to perhaps find some assistance or an answer to your question. Then, of course, you don't have to use all these platforms and apps and things. You are welcome to just send me an email too. My email address is in the show notes, so peter@pvdz.co.za. If you've got a question, any suggestions for the podcast, or if you need some tax advice, you are welcome to just drop me a mail. So, normally the podcast, I try to make it not too technical, not too long, but for today's episode, there's a case that's been in the news and that's made some headlines. So I think it would be good to talk about the case a bit and share my views on what the possible broader impact could be. Unfortunately, I've just recorded the Afrikaans version of the podcast too. So if you didn't know and you want to listen to the Afrikaans version, there's an Afrikaans one on Apple and Spotify too, Tax Break in Afrikaans. But that the episode is about 10 minutes longer than the normal episodes. But I do think that this case is quite complex, and hopefully you find the long discussion helpful. Right, so let's get straight to it. The case is a GAAR case. It's the ABSA case. So it's one of the 4 cases that I've mentioned in episode 73 as well. That's now sort of progressed to another step in the process. So I think it is important to understand the 2 aspects that we are talking about, to understand how this case came about and what it is and isn't. So what this case is initially when SARS assessed when SARS applied the GAAR to ABSA, part of the process of applying the GAAR is that there must be a Section 80J notice that's issued. And ABSA was of the view that Section 80J notice was legally flawed. So ABSA launched a review application to the High Court to firstly set aside SARS's decision not to withdraw the flawed Section 80J notice. And it seems like later on that application was amended to also then set aside the assessments that flowed from this flawed Section 80J notice. The High Court entertained the review and found that ruled in ABSA's favor. SARS appealed to the Supreme Court of Appeal, which ruled that the High Court shouldn't have entertained the review. And as part of 5 other tax cases dealing with review applications to the High Court, this case was, and the review application was considered by the Constitutional Court last year in a batch of cases specifically dealing with when the High Court would have jurisdiction to review if one looks at the provisions of Section 105 of the Tax Administration Act. Right, so that review application was based on the fact that that ABSA argued that the Section 80J notice was legally flawed, and there were two legal flaws or errors that ABSA alleged that SARS made. So because the Constitutional Court found that the High Court had the jurisdiction to review, this specific judgment is now the Constitutional Court dealing with these two legal questions. So what's very important is it's not the normal process of objection, appeal, going to the tax court, and so forth. What it does seem to me to like it is the case if you look at the judgment, there is mention of a Rule 31 statement and of penalties being considered in another dispute. So it would seem to me as if there is a normal Chapter 9 dispute process that I'm not too sure if it's proceeded or if it was perhaps pending the outcome of what happens here, it would go ahead or not. But it seems like there is another dispute process where possibly other aspects of the assessment and the application of the GAAR could be considered. Right, so I don't know, but it seems like that's the case from the judgment. Okay, so before we go into the two legal errors that the Constitutional Court had to then consider, if we look at the facts and what the transaction looked like, so ABSA subscribed for preference shares in an entity PSIC3. PSIC3 used those funds to subscribe for preference shares in PSIC4. Another South African entity, PSIC4, it seems made a capital contribution to an offshore trust, the D1 Trust. And the D1 Trust then on-lent the money to MSSA, which seems like it's a South African entity, within the Macquarie Group. And perhaps important here is from the judgments in this court and the earlier courts, you get the impression that the pref shares that in which ABSA invested was a product that Macquarie introduced to ABSA. Right. So on that on-lending, there would have been an interest payment by Macquarie to the trust, and from what I can see, that interest payment, the interest received by the trust was then exempt under Section 10(1)(h) because the trust was a non-resident. If that interest vested in back to PSIC4, which the PS was the capital the beneficiary, or the not capital that made the capital contribution, and that was the beneficiary of the D1 Trust, which is a resident, that the 10(1)(h) exemption would not have applied if one applied the conduit principle or Section 25(b)(2)(a). So then within that trust, and it's not exactly clear how that was done, the interest from MSSA was swapped for interest in Brazilian government bonds, which then qualified for an exemption under the double tax agreement. Although it also seems again from the judgment as if whether it really qualified or not could be debatable. Now that interest from the Brazilian government bonds, if that vested in a president, the exemption would still stand. So as a result of that swap, the interest that accrued to PSIC4 now qualified for exemption in the hands of a resident. And if one stands back a bit and you look at the overall effect of this arrangement, sort of the two ends of it, you've got the deduction for a South African entity that paid the interest, and that same money sort of flows on back to ABSA in the form of exempt preference share dividends. So you've got a deduction, while on the recipient side, eventually you've got exempt income. Okay, so one can understand why SARS was concerned about this. Okay, what SARS then did, they applied the GAAR to ABSA. And remember, ABSA was the subscriber for the preference shares issued by PSIC 3. And the two legal questions that the Constitutional Court had to deal with, and it was the judgment in principle was really limited to these two legal questions, because this is the basis on which the review application was made to say, but the ATJ notice was legally flawed. Was ABSA even a party to this arrangement, this avoidance arrangement? And did ABSA get the tax benefit? And by implication, could SARS apply the GAAR to ABSA if it didn't get the tax benefit? Right, so it's an interesting judgment, a long one. It exceeds, I think, 150 paragraphs. And there's a majority judgment that was written by Judge Majid and the minority judgment written by Judge Rogers. So the idea, we are also already quite far into the episode from a time perspective. So the idea is not to cover everything that's in these 150 plus paragraphs of the judgment, but rather to highlight some of the aspects on that both of these judgments, how they dealt with the two questions that I think is important to understand the bigger picture. What I will do, I have included in my outline and a few notes that I've got some paragraph numbers. So then you can, if you want to go and read in my mind, the critical paragraphs, you can go and look at them. So the first question, was ABSA a party to the transaction or not? So ABSA alleged that it subscribed for the preference shares with the understanding that this money would go to MSSA, but it wasn't aware of all the middle steps that happened in between the money going from ABSA to MSSA. So Judge Majid in paragraph 54 said that the term party must be interpreted broadly, so it's objectively any person who forms part of the chain of transactions that constitute the arrangements, whether that party knew about all the steps or not. And then in paragraphs 56 and 60, the court goes into why this is the correct interpretation. So what they say there is that if you don't interpret it this way, there is a risk that parties could willfully arrange to not know about the other steps, and in that way avoid the GAAR consequences that should follow. And if that happens, then the GAAR wouldn't achieve its purpose. So basically saying, if an investment advisor offers you, could then come with a product for whatever reason to avoid the tax, the GAAR, not tell you what's happening inside the box of this product, and that would then keep you out of the way of the GAAR, although you would get the benefit. So that's really the court's reasoning there. What the majority judgment does say is in paragraph 58, whether you've had knowledge of what happened there could possibly have an impact elsewhere. For example, when you're looking at penalties. Although I think, again, if you look at how the penalty table works, as soon as the GAAR has been applied, I interpret that table to say, but then the penalties would follow. But I suspect that's possibly something that if there's a Chapter 9 dispute process going on, that might be addressed over there. Right, then the minority judgment. So Judge Majid was of the view, and the other 8 judges agreed, that ABSA was a party to the transaction because it formed part of the chain of transactions. It was a party to that chain. Judge Rogers, on the other hand, paragraphs 119 and 132, said that the questions to consider was, firstly, what was the arrangement? And secondly, why was it impermissible? And in the context of what ABSA did, it's important to ask, to what arrangement was ABSA a party? So ABSA was a party to the first step, the last one where the dividends flowed back. But if they didn't know about the other steps, they couldn't have been a party to them. And if one had to interpret it in any other way, so in other words, the way that the majority judgment interpreted this, the outcome would be very unfair that results from that. Now, obviously, I don't have the benefit of being part of the whole build-up to all of this, knowing exactly what the arguments were that were advanced in the application and in court. But I would have expected there perhaps to be a bit more of a focus on which arrangements are the avoidance arrangements. So, in other words, the concept arrangement is very broad. So if I sell you goods or I render services, even something as simple as that is an arrangement. But an arrangement only comes within the realms of the GAAR if it is an avoidance arrangement. So I think there might have been something to say, but although ABSA was a party to the arrangement, was it really a party to the avoidance arrangement? So perhaps more of a focus on the arrangement and then what whether ABSA was a party or not. But it may be that argument was advanced or not. It's difficult standing on the outside to say. Right, so that's the party question, or the to say, but was ABSA a party or not? Then on the tax benefit question, to say, but did ABSA really get the tax benefit? So what ABSA argued is that what it received was a preference dividend, which would have been exempt in any event, and somewhere in this bigger chain of transactions, someone else enjoyed the benefit of having income being exempt that would not otherwise have been exempt. So Sash, on the other hand, argued that ABSA was the eventual beneficiary of this benefit that arose, and therefore what ABSA got was the tax benefit. So very important statement, although I think it disappears a bit if you look at the rest of the judgment again. What Judge Majid said in paragraph 78 regarding the interpretation of section 80 cap B, that provision empowers SARS to determine the tax consequences for any party to an impermissible avoidance arrangement. So in other words, if you are a party to that impermissible avoidance arrangement, whether you are the party that get the tax benefit or not, SARS may determine the tax consequences for you. So what he then also said is that this didn't really matter, because in the majority judgment's view, ABSA also got the tax benefit. So the reasoning as to why ABSA got the tax benefit, that you will find in paragraphs 79 to 96 of the majority judgment. And what that reasoning really says is that to determine whether there's a tax benefit, the transaction must be stripped of the avoidance features. So in previous case law under the old GAAR, the test for tax benefit is to say, would there have been tax but for this transaction? So the courts in this instance then interpreted this but for test. So what Judge Majid said is that the but for test is, but for these avoidance arrangements or these avoidance features, what would the outcome have been? And if you then strip the whole arrangement of the avoidance features, if there is then a benefit from a tax perspective, then a tax benefit exists. So the court said that ABSA, the exempt preference dividends were functionally or in substance equivalent to earning taxable interest. And that's where ABSA derived the tax benefit, either in the form of what they received would have been taxable interest, or it would have been a lesser exempt dividend. So personally, and perhaps I'm looking at it too technically, I'm struggling with that argument a bit. If you're saying what ABSA received on the preference share investment was functionally taxable interest, in my mind, that argument sort of goes into the world of Section 8E and 8EA, where you've got specific anti-avoidance rules that would target shares with the characteristics of debt. So clearly, these preference shares didn't fall into these rules. And to argue that what ABSA received in respect of these shares was functionally really interest, I think in my mind sort of blurs the line between the GAAR and Section 8E and 8EA, or it could make very interesting arguments for preference shares that do not fall into 8EA to possibly still be a bit of a problem. I don't know. I don't think that was necessarily what was intended here. The one that I think, in following the overall logic and reasoning of the majority judgment, would make more sense, was to say, but had PSIC4 or the trust paid tax on the amount that was now converted to being exempt, there would have been lesser dividends for ABSA. So that's why ABSA benefited from all of this. And it seems that that's really sort of the reasoning where the majority judgment go, although there is this, I'm not sure if one can call it a hedge, but sort of hedging the argument by saying it's either the lesser dividend or functionally really something that should have been taxable interest. If we look at the minority judgment, so Judge Rogers, paragraphs 134 to 137, takes the position that the tax benefit is it's a defined term, so it's it really refers to a liability for tax under the Act that was reduced. And the tax benefit, to determine whether there's a tax benefit, the but-for test is to say you need to compare what actually happened to a plausible counterfact, and then see what the tax difference would have been for the parties involved. So the step that could plausibly have been different is that the interest from the loan may not have been converted into the Brazilian government bond interest. And if you then apply this test, the benefit, so in other words, the parties whose tax liability would be less, would have been either been the D1 trust or PSIC4, because they received interest that was now exempt that would otherwise, or but for the swap between the interest and the Brazilian bond interest, would have been taxable. But on that definition, it's not ABSA. And linked to all of this, Judge Rogers also states his view that he's of the opinion that only a party who obtained the tax benefit, only that party's tax position should be adjusted under Section 80 capital B. So at an ABSA level, it was really just how much dividends that would ABSA have received. But that's an economic benefit. That's not a tax benefit. There was no reduction in ABSA's tax liability because the dividends that they received would have always been tax-free. Right, so hopefully that gives you a bit of a perspective on the two legal questions or the legal flaws that the court considered. What can we take home from this? I think 4 points in my mind. Firstly, as the title of the previous episode was, be careful of the GAAR. Be very, very careful of it, especially if you're looking at something, any type of transactional arrangement that looks a bit aggressive or that has got this flavor of a tax arrangement, a tax scheme to it. Be very careful of the GAAR. Secondly, who can be considered a party? I think this judgment by the Constitutional Court tells us that we need to interpret it could be any person who's part of the chain of transactions. So you may be a party to a transaction that, although you don't think you're getting the direct benefit, being a party to it would already possibly put you at risk. Thirdly, where the adjustment can be made. So it's not necessarily the party who gets the tax benefit. I think there is some authority for that in this judgment. So if you are not perhaps it's not your tax liability being reduced, but you're sharing in the economic benefit somehow. You may possibly be at risk of the GAAR being applied, although it's not your tax liability being reduced. And then lastly, the concept of tax benefit may be wider than you think. So even if you don't think it's your tax liability being reduced, if you share in the economic benefit of that, you may actually be deriving a tax benefit, or there could be an interpretation based on this judgment that you are deriving some form of a tax benefit. Right, so that was a mouthful, a long episode. I hope that you found it useful. Just a quick reminder, as always, nothing in this episode is intended to be tax advice or a replacement for fact-specific tax advice. Until next time, goodbye.